So it's a topic where I as criminal lawyer, I learn a lot on many things which I don't know, the financial markets, the details of how the financial market, the banking supervision works. Because on a daily basis, I'm more interested how authorities, agencies like this one, work in combating crime, for example. And we know that this is not an authority to combat crime, but it will also have impact on combating crime. By the way, the photo is not the Anti-Money Laundering Authority, because it doesn't exist yet. We don't even know where it will be. And this is a building in Luxembourg, and unfortunately, the authority will not be in Luxembourg, which I regret a lot as a person active in Luxembourg, working in Luxembourg. So certainly this will not be this building. This is the building of my faculty. And the sculpture in front of it, let's hope, doesn't represent the future of the authority, which will look much nicer and in a more organized way, about which I will try to convince you today. So my job is to update you on this initiative. This is an initiative from 2021, which follows a reflection that something is not working with money laundering, with combating money laundering. Actually, money laundering is working quite well because we're not combating it enough. So something has to be done. Is it the first time we're having this reflection? No. It's more or less the 6th time that we're having this reflection, because part of this initiative is the 6th directive, and actually it turns to be a regulation on anti-money laundering. So it's a bit part of a continuous effort of saying, not enough, let's do more. Not enough, let's do more. We academics, we like to fill papers with reflections, whether it makes sense or not, what money laundering as an offense, as this whole system, what it means for combating criminality, whether we should even have criminal law anymore. Maybe we should only combat money laundering and do nothing else. But that's a reflection I will leave aside for today, because there is enough material to discuss the authority, and that's my job in the first place. The current legal framework on combating money laundering and financing of terrorism. I will tell you about the policy developments that of which the idea of putting in place this authority is part of. And then I will go more into details on the proposed AMLA, as we call it, Anti-Money Laundering Authority. Speaking about its structure, how it's going to be made up, and especially about its functions. So to start with, the place of EU in combating money laundering starts more or less at the beginning of the 90s with the first directive, Anti-Money Laundering Directive from 1991. We had several of them, and the ones that are now in place is the 4th and 5th, the 4th from 2015, which was amended by the 5th one, and the 5th one actually didn't replace the 4th one as it was with the previous one, but it just provided amendment. So if you want to have the current framework, you have to read the 4th and the 5th together, and you have a nice consolidated version on Eurlex where you can read how this looks. To this has to be added a directive which some call the 6th one, but that's not fully true. It's rather a criminal law directive from 2018, which provides the definition of money laundering for the purposes of criminal enforcement. So this is where money laundering becomes a criminal offense and is prosecuted as such. The 4th and the 5th are about preventing money laundering. So this is about the duties of banks, financial institutions, and all other obliged entities, and these entities, the number of these entities has been growing since '91 constantly. And that's where you will find rules on supervision. So who supervises, who enforces those rules on preventing money laundering? I just need this to check the time. The obliged entities have a number of duties which are meant to guarantee that they prevent money laundering. These duties can be summarized as first, identifying the customer and verifying the customer's identity. Second, identifying the beneficial owner and taking measures to identify this person. Third, analyzing transactions and business relationship, monitoring this relationship, and informing the authorities if something looks suspicious. So these are the duties in the nutshell. The model of preventing money laundering is now based on risk assessment. So it used to be a more formal task of checking certain prescribed criteria. Now all the authorities, all the entities which are obliged to conduct these efforts are obliged to have their own risk assessments, of course based on many guidelines that they receive from different supervising authorities. And that's one of the troubles of the system. Why? Because there are many of these guidelines and they come from different sources. FATF, national authorities, national central banks. So there is a plethora of different guidelines, which makes the life of entities more difficult. So one of the ideas of having one authority is to streamline and, so to say, in a non-technical way, harmonize these guidelines. So this is what we have, and we still have in the 4th Anti-Money Laundering Directive, and the 5th came in especially because of the proliferation of cryptocurrencies, which created additional difficulties, and the framework had to be amended because of cryptocurrencies and virtual assets, which was done. But as my former colleague wrote, before even the 5th directive entered into force, it was already outdated, because this market changes so quickly that it turns out that what they managed to put in was in, but there was already a lot happening outside of this framework. And that's why we need another reform. So that's the framework in the nutshell. Let's have a look at the reform that is proposed. This is the chronology of the reflection after 2018. It started with several scandals which concern several banks, for example, ABLV Bank, the Danske Bank. These are two banks. So Danske is Danish, but both scandals took place in the Baltic countries, concerned money laundering of assets linked either to the Russian Federation and its president, or to North Korea. Another scandal was the Pilatus Bank, that's Malta, about which the famous journalist Daphne Caruana Galizia reported, and as you know, she then died in she was murdered for her efforts to publish on scandals like that. So these scandals led to the reflection something has to be done, which resulted in an action plan, and two main problems were identified by the European Union. The first one was the major divergences in the application of the AML and CFT framework, CFT combating and financing of terrorism framework. And the second was the inconsistency of supervisory standards and insufficient cooperation and coordination between national supervisors. How to remedy these problems? The first one, major divergences in the application of the framework resulted from the fact that all these instruments were directives. So from the first one, we're speaking about the first, second, third, etc. directive, the fourth and the fifth are directives. What does it mean? It means that the national, the member states have to implement them, and they have a margin of freedom how to do it. This results in inconsistencies. How to remedy this? Change a directive to a regulation, because a regulation is directly applicable. Then you don't have this problem. So that's the proposal number one. And if you have inconsistency of supervisory standards, if you have insufficient cooperation between national authorities, the remedy is to put in place an EU authority that would assure consistency of standards and would assure cooperation of national authorities. And that's the second idea. And these two ideas form the core of the reform that was proposed. The reform is composed of 4 acts. The first 2, so the numbering is a bit confusing. The first 2, it's a regulation and a directive. These 2 acts will replace what we now have in the 4th and the 5th directive. So it will not be an amendment. The 4th and the 5th will disappear and will be replaced by these 2, by a regulation and a directive. So the directive, 4th and 5th, put together contain 2 types of rules. Rules on the duties of obliged entities and rules on supervision by national authorities. Now these 2 groups of rules will go to 2 different instruments. The duties of obliged entities will go to the regulation. And because it will be a regulation, they will be properly harmonized because they will be directly applicable. The rules on supervision cannot go to a regulation because this is done by national authorities. So of course they have to go to the directive because there every member state has its particularities, how this will be put in place on the ground. But to avoid too many discrepancies, we have the third element of this reform, which is the Anti-Money Laundering Authority, on which I will speak more in details in a second. So this is the third element of the reform. And the fourth element of the reform is actually already adopted. It's a regulation on information accompanying transfer of funds and certain crypto assets. That was actually part also of a reform of the virtual or crypto assets market in the European Union, and it was adopted already discussed together with the MiCA regulation in the context of virtual assets. So this fourth element actually is already in place. But from our perspective, let's say it's more of a minor issue for this whole composition of the preventive framework. As you can see, the criminal law aspect is not part of it. We have the criminal law directive from 2018, and this is not affected here. It doesn't mean that the relationship is not changing. The definitions of criminal activity for the purpose of this preventive framework and the criminal law framework are put now together. They were different so far, now they will be the same, because this framework will borrow the criminal law definition, but let's say this we leave aside. So that's the general framework. Where do we stand? We have, so the fourth is adopted. For this 3, we have already the 3 versions of the text. So we have the proposal of the Commission, we have the general approach of the Council, and we have the position of the parliaments, and the trilogues have started. So we are at the stage of the trilogues for those instruments that are already, they are going relatively well, as far as I can say. And as far as our authority is concerned, we have also negotiations, or rather competition, where this authority will will have its seat. As said, Luxembourg was part of this game. They withdrew. There are several cities which are still in the game, and we will know, I think, relatively soon where this will take place. But at this point, we do not know. The idea is that the authority becomes operational in 2026, so it's still a bit ahead of us. Let's see if this deadline is kept. So now I will go more into details on the authority as such. The authority will have three main functions. It will execute supervision, direct supervision of certain entities. It will coordinate and facilitate supervision of national authorities, and also it will facilitate investigations by FIUs, financial intelligence units. So these are its three roles, and there is a fourth role, which is issuing guidelines. And I think this role will be extremely important because, as you will see, this direct supervision will be relatively limited to certain entities. Otherwise, it will be coordination, facilitation, very important, but also issuing guidelines. And because of this plethora of guidelines that we have, we think that this might be one of its key functions. In terms of structure, it will have a general board where the member states are represented, and it has two compositions. There is a supervisory composition and there is an FIU composition, depending on which matters it will decide. But it will be run on a daily basis by the executive board, in particular by its chair, and 5 independent full-time members. So this will be the essence of running this authority. It will also have an administrative board of review, which will have a non-binding role on the decisions of the authority. A very interesting aspect and quite important is the difference between the power to directly supervise and to supervise indirectly. For most obliged entities, the AMLA will execute indirect supervision. Indirect in the sense it will go through national authorities. But for some, it will execute direct supervision for what is called, and it's a term from the regulation, selected obliged entities. These are entities which are considered high risk with strong cross-border activity. And how to determine which of these authorities fall into this category, and most of them will not, is a very interesting and complex issue. By the way, all that I'm explaining, I'm in the first place explaining the proposal of the Commission. As said, we have the 3 texts, which differ slightly, and especially this competence to directly supervise, the EU Parliament has slightly different vision how to define them, but I will not explain this in details, especially that this is still subject to negotiations. So which authorities will be directly supervised by the AMLA? So in the first place, we're speaking only about credit institutions and financial institutions. Credit institutions, these are banks licensed under Capital Requirement Directive 4. Financial institutions, we have a list of different institutions based on different instruments that regulate their area. So, for example, financial holding companies, insurance undertakings, MiFID investment firms, undertaking for collective investment in transferable securities, etc., etc. Now, in order to decide which of those entities will be supervised by the AMLA directly, we have a two-step procedure where for the first step we even have also two steps, so it's a relatively complex procedure. The first determination in the first step, so in the first step we want to determine which entities are particularly risky. So we do it by first establishing those that are active in many member states. For credit institutions, we need credit institutions that are active in at least 7 member states. So they have to have an establishment in 7 member states at least. For financial institutions, we need those financial institutions that are active at least in 10 member states, but they do not have to have an establishment in 10 member states. They can offer services in some of those states. They don't need to be present there. And there, once we have a list of those who fulfill these criteria, the authority will assess their risk profile. And they will do it based on their own rules that they will predefine. So they will issue regulatory technical standards that they will be adopted, and based on those, they will assess which of those institutions are low, medium, significant, or high risk. And this is the first step. And when they have the list of those institutions, they will, in the second step, decide which of those are really risky and which of those they will effectively supervise. And here in the second step, you have the criteria for the second step analysis. So for example, for credit institutions, they have to fulfill 2 criteria. First, out of this, you remember at least 7, 4 in 4 member states, they need to acquire the profile of high risk. First, and second, the credit institution has been under supervisory or other public investigations for material breaches of AML CFT requirements in at least one of those member states in the previous 3 years. So from this you can see that in order to get on this list, you need to be very big, you need to have high risk in several countries, and something had to go wrong already in the previous years. And it is similar for financial institutions, though criteria are slightly different. So the outcome of this exercise will be a relatively short list of entities. Now, one remark, the Parliament does it a bit differently. The rules are equally complicated, but the accents are slightly different. For all other institutions, the AMLA will execute only indirect supervision. So this will go through national authorities, but there remains the possibility that AMLA decides, it needs an agreement of the Commission, decides to take direct supervision of such an authority. So they can pick an authority and supervise it when, in the nutshell, when there are problems with this entity, and the national authorities are not managing to supervise it properly. So this is the summary of the rules when the AMLA can pick an authority and supervise it directly. In terms of competence, that's very detailed. Please don't read it. And anyway, the PowerPoint you will get afterwards, but I summarize it for you. So we have this direct supervision from the perspective of entities. We have direct supervision and we have indirect supervision. For direct supervision, there are 3 types of measures that AMLA will be able to use. The first category are administrative measures. So they will do some sort of investigation, they can ask for information, and then they can impose certain measures. So for example, a plan to restore compliance. They can restrict business. They can request changes in the governance structure. So these kind of administrative decisions can be imposed on an entity. These are decisions in the sense of European law, and a remedy in front of the General Court will be possible. For lack of compliance, they have two more, let's say, punitive measures: administrative pecuniary sanctions and periodic penalty payments. Periodic penalty payments are the payments that are requested as long as you do not comply, you have to pay. And administrative pecuniary sanctions are simply sanctions for not complying. So even if they start complying, they still have to pay those. So they have a punitive nature. I will come back to that in a second. For all the other entities, the duties or the powers of the AMLA are monitoring, coordination, making sure that the national authorities work in a coordinated fashion, that they have the standards, they supervise those authorities, they help the FIUs to do their job. Coming back to the pecuniary sanction with a little bit more details. And this is a reflection from my field. What it means, what is hidden between the name administrative pecuniary sanction. And this can be a topic in itself, so maybe I can leave it for the Q&A to go more into details, but I just want to signal to you that the fact that this is administrative law, because this is not criminal law, this is an administrative sanction, doesn't mean that we do not understand it as criminal. And where it's important for the guarantees that the entity in question will have in this procedure. We have some of those guarantees in the regulation already: the right to be heard, the right of access to the file, and those rights shall be further developed by the Commission. Is this enough? It's a question, because according to the standing jurisprudence of the European Court of Human Rights, if something, I simplify, looks like a criminal sanction, it has to be treated as such. I can do it in a more technical way, but I leave it for the Q&A. And there is jurisprudence that goes back to the 70s, more or less, on this matter. So if this can be understood as criminal charge and criminal sanction, even imposed by an administrative authority, it comes with duties. And the Parliament seems to have recognized this and added several guarantees to the proposal. Few remarks on the interaction with national authorities. It is possible that the authority discovers criminal activity in its direct or indirect supervision. They are supposed to inform national authorities. That's in the original proposal. And there is this very interesting rule that they should refrain from proceeding if there is res judicata. So in order to avoid a bis in idem, so being prosecuted once again in the same case, they should refrain if there is a national proceeding which is ongoing. That's also a topic on which we can spend more time, and I maybe leave it also for the Q&A, because actually there is a lot of complexity hidden behind this rule. So we can come back to this. In the process of elaborating the new versions, we discovered that it's not only the question of interaction with national authorities, which is a problem, but there is also OLAF, there is also EPPO, and some other players on the EU at the EU level, and rules were also proposed on informing, exchanging information with the PPO. This comes, of course, with other headaches related to data protection, to the rules on exchanging data, etc., etc. Last slide, and the final reflection. It's clear that the authority is based, it maintains the risk-based approach, but if it works as it should, it will add to better understanding what are the rules in Europe, to more harmonization of rules. That's one of its main functions. So it will be a supervisor for the few, but probably a regulator for the many. So with this, I stop. Thank you very much. And there are probably some issues left for the Q&A.